The Punjab and Haryana High Court has denied bail pleas of a Class 12 students, a minor and a prime accused in the 2017 Rhine school murder case. The single bench of the Justice Arvind Singh Sangwan observed that the benefits of the bail to a juvenile under Section 12 of the Juvenile Justice, Care and Protections of Children Act 2015 could not be given to the accused, as the Supreme Court has directed to treat him as an adult for the purpose of trial. The petitioners, who was a student of Class 11, had been charged with the killings of 7-year-old inside the school washroom in 2012. The Punjab and Haryana High Court has dismissed the bail plea filed by the school students accused in 2017 Gurugram private school murder case. The petitioner, who was a student of Class 11, have been charged with the murder of a 7-year-old child inside the school washroom. The Principal Magistrate, Juvenile Justice Board, Gurugram, had earlier declined the grant of bail to the accused. Thereafter, the Appellate Court Additional Session Judge, Gurugram, also dismissed the appeal to move challenging the board's decision. The High Court has now dismissed the revision plea challenging these orders. The revision plea was moved on the ground that these orders denying bail were passed while touching upon the merits of the case. Justice Arvind Singh Sangwan passed the order while noting that the accused school students had to be treated as an adult in line with the Supreme Court orders passed on the issue. The Supreme Court had, in its order passed in February 2019 and in April this year, stated that the accused was to be treated as an adult for the purpose of deciding on bail. The High Court therefore stated that there was little scope for it to ascertain whether the bail could be granted under Section 12, grant of bail to a juvenile accused of the Juvenile Justice Act. Though it is well-settled principles of law that an application for the bail filed by a person who is above 16 years of age and is alleged to have committed a heinous crime pending preliminary assessment by the Juvenile Justice Board can be allowed. However, this court is not inclined to grant any relief to the petitioners in view of the order dated 28/2/2019 passed by the Honorable Supreme Court, directing that for deciding the bail petitions, the petitioners be treated as an adult. Therefore, there is little scope for this court to find out whether the petitioners can be granted the relief under Section 12 of the Act. The High Court, in dismissing the plea of the accused for bail, relied upon detailed orders that they have been passed by the Supreme Court and the Juvenile Justice Board that is overseeing the investigation in the case. The court noted the prosecution has cited certain witnesses who are minors, including the sister of the deceased, and therefore possibility of tampering the evidence cannot be ruled out at this stage in view of the totality of the circumstances and the affidavit filed by the CBI. In this backdrop, the court concluded that there was no ground to grant the concessions of bail to the accused and dismissed the revision plea. Bureau Report.